thank you all for coming. I think some of you have been before, probably 4 or 5. So this is the last in the 3-part series that we've been going through from a GDPR readiness perspective. I think we've concluded as we've got through these that nobody's ready and there's probably more questions than there is answers. But does anyone not feel like that? Put your hand up. Okay, fair enough. So I'll give you a very brief background on TIG for those of you, and I don't recognise some of you, so there's some new faces. TIG, we like to sort of brand ourselves as a digital MSP. So really what that means is that we've got 3 key parts to our business, which is transformation, that's where the sort of digital piece comes from, and managed service provider and cloud service provider. So from a cloud service provision, we are Azure 365 Gold partners. We're a managed partner by Microsoft. We do also run events here funded by Microsoft around Azure and some of the technologies that you can take advantage of. Managed service provision, we're 24/7 managed service, focused around the mid and the smaller enterprise markets. We've got clients across a broad range of sectors. And the transformation piece is really where we're looking at clients' requirements from a technology perspective and a strategy and helping them take that journey to what ultimately may be a cloud-based solution and management. So, interestingly, we've been doing some statistics recently for one of our cloud seminars, and if you look at the rate of change within the sector, so if I was to say to you, where do most people buy their music from? So you had HMV that took 90 years to sort of build their brand, Apple and Spotify. So if I asked you to order those, which order would you put them in as the one who sells the most music, middle, and then third? Any idea? So who do you think is top? Who's shouting that? Spotify. Yeah. And then market cap, I think, is now 60 billion market capitalisation. Bigger than Tesla, funnily enough, which is another interesting one. But who do you think second, HMV or Apple? It's HMV. Bizarrely, there's more people buying vinyl now and CDs than there is doing iTunes downloads. So yeah, iTunes market is just collapsed, and that's predominantly because Spotify has really transformed the way that you buy and keep your music, where iTunes just couldn't really keep up with that rate of change. If we were to do another one where we said, so if you look at, focus on technology again, if you look at Ford, Toyota and Tesla, so of those, who do you think the largest from a market capitalisation is? No. Ford. No, sorry. No? Toyota. So Toyota is the largest. Who do you think is in the middle? So you've got Ford and Tesla left. Ford? It's actually Tesla. So Tesla's got a 58 million market cap, where Ford's only 42 million. So yeah, we know that everything's going towards the cloud. Everyone keeps telling us that. Do we believe it? Well, I think people are starting to believe yes. Because all of the vendors are changing the way they actually transact with us as clients, and they're moving all their services to cloud-based services. So if you look at the most of the sort of key cloud providers, so Microsoft won't do any subscription, won't do any perpetual license services, probably are in the next 2 or 3 years. They'll be phased out. Everything will be subscription-based, and they've made that quite clear. AWS is already subscription-based, Google's subscription-based. The other one on the horizon is our friends from China, so Alibaba Cloud, so Ali Cloud, which I know sounds silly, but they're gaining market share rapidly. Question will be, would you put your financial data in something which is sponsored by the government? That's a political conversation. We don't do politics or religion in these sessions. Alan will touch on a little bit of politics from a positioning perspective. So, everything's going towards cloud services, and really the idea of today is when you had your data locked up in filing cabinets or you thought it was on a drive, it's all fair enough, you knew where to track it and manage it, but now your data is spread across multiple cloud providers in multiple jurisdictions in some cases. So really it's about understanding how you get ready for GDPR from a business perspective, and Alan's presentation is more about preparing your business for GDPR. From a TRG perspective, we'll talk to you about the technologies that you can use to drive some of those services. And for TRG, one of the sort of fundamental technologies that we focus on for that requirement is enterprise mobility with security. For Microsoft, it has all the components you'd expect. So, data encryption, expiry dates on documents, two-factor authentication, and so on, and some other clever components. So we'll talk to you about that on a one-to-one basis and go through. We do have some sessions around EMS as well that we can talk you through another day. But really today, because Alan's got a fair amount to go through, is focused around GDPR and the preparation for GDPR. So if you've missed previous sessions, we'll send out we'll send out a compilation of all the slides, and we're scheduling some more sessions in the new year. We just haven't finalised the dates yet. So our guest speaker is Alan Calder from IT Governance Limited. I'll let him introduce himself because he does a nice intro leading into position himself from a sort of an industry perspective. So, hand over to you, Alan.
Good morning, ladies and gentlemen. So I'm Alan Calder. I'm the founder of a company called IT Governance, which I set up some years ago in order to help organizations deal with data protection and what's now called cybersecurity, on the basis that boards needed to take control of those kind of issues if anything was to happen. And exciting for us in the last couple of years, the combination of journalists and regulation has driven our business to grow now at a rate well over 100% year on year, and it looks as though it'll keep on doing that for a while. I've been involved in this sector for about 20 years. The first book I wrote became the Open University's postgrad textbook. It's in its 6th edition. I don't get much time for writing, sadly. It's much more relaxed than anything else. The business itself is very broadly in this niche called IT governance, risk and compliance. While we deal with governance, service management and so on, the biggest part of our business is around information security, cyber resilience, penetration testing, and of course data protection with GDPR. And we provide products and services from software and documentation template toolkits through practitioner training to consultancy, pretty well any mix of products and services that an organization might want to enable them to address the challenges of being compliant in today's challenging competitive market. And today I'm going to be talking about data controllers and data processors. Seems like a pretty dull bit of GDPR, but it's pretty central to being able to work out how you go about complying, because if you are a data controller and you think you're a data processor, you're in trouble. If you think you're a data processor and you're actually a data controller, you're almost certainly in even bigger trouble, because you'll have almost everything wrong. So we'll talk about the obligations of controllers and processors, how the data breach reporting obligations fit into those definitions, how liabilities, penalties and so on can be imposed, and how those work through the controller-processor relationship, and then a brief look at subcontracting and joint controllers, and maybe even touch on the challenges of who is in control of what in the cloud. On Christmas Day, we'll be just 5 months from the point at which GDPR comes into force. And coming to force means that that's the day on which you need to be in compliance with GDPR. It's not the date after which you need to do stuff. The data that you're holding inside your organization, you need to be holding in compliance with GDPR on the 25th of May. And that means all of the data which you've gathered ever since you set the business up, or over the last 5,000 years, whatever it is that your data czars have been happily gathering personal data. You're going to, when you think about it, if you haven't yet, you're going to discover that you're holding large amounts of data that you've got no legal basis for holding, and therefore technically, legally, you should stop doing anything with it. Of course, everybody will go on doing stuff with the data they're holding illegally, and that means sooner or later you're going to be faced with either a data subject access request that's quite embarrassing, particularly as it will lead to some form of investigation, or having to report a data breach which will reveal that you're holding data that you really shouldn't be holding. So let's talk about definitions. The starting point for definitions is personal data. GDPR defines personal data essentially as anything that can identify a natural person. GDPR is concerned with natural persons, not legal persons, so a company is a legal personality. It's able to enter into contracts because it's given a personality under law, but GDPR is concerned only with natural persons. Any information relating to an identified or identifiable person is personal data. That includes obviously names, addresses, national insurance numbers, passport numbers, but it includes biometric and genetic information. It includes online identifiers, IP addresses, anything that can identify somebody. So that's challenge number one. What personal data are you collecting? And the second challenge is, what capacity are you collecting it in? GDPR defines in law for the first time a controller and a processor. And the notion of a controller and processor is not an entity level thing which says you're a controller in relation to everything that you do. It's process related. You can be a controller in relation to one processing of data and a processor in relation to another. And that means that for every processing of data, you need to establish what status you have. The controller is defined, and all the definitions in GDPR are listed in Article 4, and you can download and read GDPR. It's in nice, simple, plain English on the European Commission website. The natural legal person, public authority, agency, any other body that alone or jointly with others determines the purposes and means of the processing. And that's the essential bit of the definition. It's the entity that determines the purposes and means of processing. So if you're looking at who's collecting data, you have to ask yourself, who has determined what this data is for and how it's going to be processed, what's going to be done with it. When you can answer that, you can identify who the controller is in relation to that processing. Now that's fairly easy to do when you're looking at your own staff. You've determined what information you need to gather about them, you've determined how you're going to process it. It's pretty obvious, you're the controller. But who is the controller in relation to data which is stored in Salesforce, for instance? All of the personal data which goes into the Salesforce application in the cloud, who is the controller in relation to that data? Who is the processor? And the definition of processor, also in Article 4, is a natural legal person. It's a third party that processes personal data on behalf of a controller. So it's taken as read that a controller may process data itself. What controllers do, they determine the purpose and means of processing. If you contract with, or you enter into an agreement with a third party of any sort for them to process data on your behalf, they are a processor. So is Salesforce a processor or a controller of the data of your customers? Is it? What instructions have you given Salesforce about how to process your data? Because processors can only operate under the direction of a controller. Processing, another key definition, means any operation or set of operations performed upon personal data that includes collection, recording, organizing, structuring, storing, adapting, altering, retrieving, consulting, taking a look at, reorganizing, anything. So processing includes letting somebody log on and look at data on a screen. So if you say to yourself, I let my contractors in India have a look at data, they don't actually process it, you're misusing the definition. They're looking at data, therefore by definition under GDPR they're processing data. And GDPR has very specific prohibitions on the processing of data outside the European Economic Area. So when you come to look at transborder data processing, you have to ask yourself, not just is somebody doing something with the data, as in they're accessing the database, but can they even see it? Because if they can, they're processing it, and you therefore have specific obligations. Notice that the definition includes destruction or erasure of data. So you're processing data at the point when you start deleting it because you no longer need it. So responsibilities and obligations of controllers and processors. As you might imagine, being clear about whether you're a controller or a processor is going to be pretty critical. And it's critical because data controllers have to determine the legal basis for collecting data, not processors, controllers. Controllers, remember the definition is, they determine the purposes and means of processing data. Therefore, they're going to determine which items of personal data to collect. They're going to determine the purposes for which it's used, which individuals to collect data about, whether to disclose it, and if so to whom, whether subject access and other individuals' rights apply, and if there are exemptions, how those exemptions should operate, and how long to retain the data for. Controllers make all of the decisions about what's going to happen with people's data. Not only make all of the decisions, they have to tell the data subjects what's happening with that data, and that includes talking about the way in which a third party might be processing or accessing or doing whatever there is to do with that data. So controllers have to, by law, have a data protection policy. So simple takeaway, go write a data protection policy. Then you're complying with one of the requirements of one of the articles in GDPR that sets out how, as a controller, you're going to meet your obligation to protect all of the data that you're determining the means and purposes of processing. You have to put in place appropriate technical and organizational measures to protect that data, to ensure that the 6 data processing principles are being applied to all of that processing. GDPR helpfully doesn't define what appropriate or technical or organizational is. It defines personal data, but not the key thing you have to do. The courts over the years are going to set out clearly what those things are. In the meantime, you have to try and arrive at some practical decisions about what to do. And one of the starting points is the recognition that you can adhere to a code of conduct or an international or national standard as a mechanism for demonstrating that you are seeking to comply with your obligations under GDPR. Processors may only process data if they have a contract from a controller. So you just think about that. If you're processing data, you're either a controller, in which case you determine the means and purposes of processing. You don't have to have a contract with a third party that tells you what to do, or you're a processor, in which case you do have to have a contract. So imagine what happens if you think you're a controller but you're actually a processor. You're in trouble, aren't you? Because you're breaking the law. You're actually a processor and you're processing data without a contract. And ignorance of the law, remember, is no defense. Negligence is probably what you would be accused of. Didn't bother to find out what the law actually required. So a processor has to have a contract, and the processor can only process the data on the documented instructions from the controller. Must make sure that whoever is doing the work for it have the appropriate obligations around confidentiality, take this blindingly ill-defined or undefined word, take appropriate security measures, respect any conditions involved in engaging a second or third level processor, assist the controller with appropriate technical and organizational measures to secure the data and to make sure the data processing principles are applied, and at the end of the processing, return the data to the controller. So what is Salesforce, a controller or a processor when you put data into the online application? When you put data into Salesforce, are you a controller or a processor? Give you the first clue is you're collecting data about your customers. So in that sense, you're determining the means and purpose of processing. You're determining we want to collect this data about our customers and we're going to process it in Salesforce in the cloud. So you're a controller. You meet the definition of a controller. But what's the relationship with Salesforce? What are you doing with Salesforce? You put the data into a third party's application. Does that make them a processor of the data? Or does it make them a platform? What's the reality? Because it's quite critical. If they're a processor, you have to have a contract which tells them what to do with your data. Otherwise, they can't do it. It's really easy for a small organization to get Salesforce to go along with a contract, isn't it? You phone them up and say, I'm sending you the new terms, just sign up, get them back to me. Otherwise, you can't process our data anymore. You're going to get a really sort of worried response from Salesforce, aren't you? Or is Salesforce just a platform responsible for processing only in very specific areas, like in terms of security and archiving, and actually you're responsible for what happens to the data in the application? What's the difference between an application sitting on a desktop and an application sitting in the cloud? All I can tell you is that GDPR, the various supervisory authorities, haven't really got their heads around what that means yet. There is little in the way of practical legal guidance. Our view is very simply that a cloud-based processor is usually a platform. The application is on the platform. You're the controller. You're responsible for what's happening in there. But the platform is a processor in very specific areas: security, archiving, access, and your contract with them needs to make sure that those things are appropriate. But we wait to see what the law actually tells us over the course of the next 3 or 4 or 5 years. So a data processor, within the terms of its agreement with a controller, may decide what IT systems to use, how to store the data, what type of security to put in place, how it will transfer the data from one organization to another, how to retrieve it, how it will operate the retention schedule in line with what the controller tells it, and how it will delete or dispose of data at the end of the processing. So if you're dealing with a cloud provider who at some point, when let's pretend that you're in dispute with them over the fees that you owe them, say we won't give you your data back unless you pay us, what legal ground do you think they've got for that? Probably none, because it's your data and they're obliged to process data in line with your instructions. How that's going to intersect with whether you pay them or not, I also don't know, but I suspect that the courts will come down in favour of the rights of the data subject, not the rights of somebody who simply wants to get paid. And those, for those who've been before, are the 6 data processing principles. So as a controller, your obligation is to make sure that all the data which you collect is processed in accordance with those 6 principles, and to demonstrate that you're accountable for doing it. Accountability is, let's start with the board, let's make sure that there's a proper governance framework that deals with it. And the starting point for the application of the 6 principles, as you probably see, really is the second principle. The data should be collected for specified, explicit, and legitimate purposes. And if for every set of data that you're gathering, as a controller, you can determine specifically what you're going to use it for, you can be explicit to the data subject, and the purpose is legitimate, the other principles are pretty easy to follow. Pretty easy to get from there to determine what the lawful basis of processing is. Be pretty straightforward to be doing it fairly because it's legitimate, specific. The data subject will know, it'll be transparent. You'll know what you actually need in the way of data. You can limit it to what you need. You can keep it accurate where necessary, retain for as long as necessary, and processed in an appropriate manner. Wherever you see as necessary in these principles, it's as necessary to achieve the purpose. Not as necessary because you came up with some other purpose, like actually it'd be really nice to keep this data in case one day I want to sue them or I want to sell them stuff they didn't know about. That's not the purpose for which you collected the data. That doesn't stop you going back to the data subject and saying, you know, I got this data from you for these purposes. I now want to use it for something else. How do you feel about that? That's perfectly reasonable, as long as it's specific, explicit, and legitimate, and their rights are observed, which is the right to consent depending on some options, or the right to opt out of the processing. But you can't just decide what you're going to do it for. You can't have a data agreement with a data subject which says we're going to process your data for reasons we still have to think of. And people do that. We've had fun with clients who give us those kinds of clauses, and we go, now look. You have to be able to demonstrate accountability as a controller. And accountability as a controller means really that when you process, for instance, when you contract with a processor and they go out of business and you get sued because of something they did, you're not going to be able to say, but they've gone out of business, not my fault, it's the processor's fault. Because the supervisor's right is going to say is you chose the processor. You are accountable. So too bad if you chose somebody who's not up to scratch. That was your choice. You're paying the fine. You're paying the compensation because you're the controller. The obligations as a controller are very significant. So we start thinking about the 6 data processing principles, but also the rights of data subjects, because Article 12 says the controller has to facilitate the exercise of data subject rights. At the moment, what we do with data subject rights is we pretend they don't exist. We hope that if we're careful enough, we can make it difficult for data subjects to do anything. We make it really complicated for them to access their information. If they've got a lawyer or a trade union representative who knows what they're doing, then we probably try a bit harder. GDPR says, actually, you don't just have to recognize their rights, you have to facilitate their rights. Facilitate means make it easy for them to exercise their rights. So that means there's a whole part of your GDPR strategy which has to say, not only do we know what the rights are, but this is how we're going to make it easy for data subjects to exercise them. And mostly, data subjects exercising their rights, we suspect, will start with a data subject access request. We'll start with somebody saying, I'd like to know what data you're processing about me. Because they have the right to be informed. They have the right to know whether what you're doing with their data is what you told them in the first place. And you're obliged to tell them everything you're doing with the data. And that includes digging into your archives, including the stuff which is backed up and goes back 28 years, and saying, I'm processing all of this data. And it's because you tell them that they then realize their rights have been transgressed massively, and they bring an action against you because you're processing data they didn't even know you were processing. They've got the right of access to it, the right to have it fixed if there's something wrong with it, under specific conditions, the right to erasure. This is not an absolute right. They can't have data erased just because they want to. If you've got an overriding reason to retain the data, like I have to keep the data for VAT records or HMRC records, then you have an overriding obligation to retain the data, which overrides their right to erasure. The right to erasure is triggered automatically if the basis on which you're processing their data is consent. You have to have, remember, a lawful basis for processing data. We mostly think consent is easy, consent is very dangerous. As a lawful basis, as data subjects, of course, we'd like it to be consent because we'd like to think we're in control of our data. As an organization, as a data controller, we don't necessarily want to rely on consent because consent triggers the right to withdraw consent, the right to erasure, and the right to data portability. And if somebody says, I want to withdraw my consent to processing of my data, but you still have a contract with them, you've got a real problem. You've got no way out of fulfilling the contract, but you have to stop processing their data. Don't rely on consent. There is a lawful basis called processing necessary to fulfill a contract, and that's the one you select. You don't select that plus consent, because then you can bet your bottom dollar they're going to say, I didn't really understand that one, I thought I was consenting, I want to withdraw my consent, and you're in a whole long fandango in the court. You just go with a single, most appropriate lawful basis of processing. So the right to erasure, the right to restrict processing while you're arguing with them over the accuracy or otherwise of the data, the right to data portability, again, it's a restricted right. It doesn't apply absolutely. They can't just phone them and say, I have a right to data portability, give me all the data you've got in a machine-readable format. It's very specifically related to data which they gave you in an electronic form on the basis of consent. They have the right to object to processing, so with consent they have the right to withdraw consent. If the basis of processing is in order to fulfill a contract, you have to give them the right to object. With consent, you can't penalise them for withdrawing consent. That's what the law says. You are entitled, though, with an objection to an alternative lawful basis of processing, to tell people the consequences. Might seem very boring, but it's pretty critical. So you can say, we're processing your data in order to fulfill a contract with you. You have a right to object to the processing. The consequences are that that will destroy the contract. That's perfectly legal, you can do that. But you can't say, I'm going to process your data on the basis of consent. If you withdraw the consent, then we'll cancel the contract, because you're just not allowed to do that. You're not allowed to penalise people for withdrawing consent. I didn't write the law. They have rights in relation to automated processing and particularly to profiling. They have the right to know what's going to happen. They have the right to know, in particular, if there are going to be decisions made on the basis of profiling which might affect them. They have a right to know what that profiling is and what those decisions will be. Automated profiling, club cards, everything that looks at how you spend, what you do, credit agencies, those are all forms of profiling. Controllers and processors have all of those obligations. They've also got what you'll get to think of really as just the Article 30 obligation. The Article 30 obligation is to keep records of your processing. And it kind of looks minor when you read it for the first time. It just says you have to maintain a record of processing activities. But it's not, because the record of processing activities has to start before anybody comes along and says, I want to know what you're doing with my data. So the obligation is not only just to have recorded in terms of every process, whether you're a controller, a joint controller, what the purposes of the processing are, a description of the categories of data subjects, who you might be sharing it with, any international transfers, the time limits for the erasure, in other words, your retention schedule, and a general description of technical organizational measures. When a data subject says, I want to know what you're doing with my data, they're entitled to know all of those things. If you quickly write them up at the point when you have a data subject saying, what are you doing with my data? Or you quickly write them up because you've got a data breach which you have to report, and one of the first things we think the supervisory authority will say is, and can you tell us what your data processing, Article 30 data processing records are? Send us a copy, please. They'll see instantly that you wrote it last night. And you've instantly got a problem, because this should be in place before May next year. How are we processing data? What are the processes that we operate in respect to every process? Are we a controller or a processor? What's happening with the data? Who has access to it? What are the controls we have in place? Because it's not possible for you to meet your obligation to embed data protection by design and by default without knowing what you're doing with data. So, takes us neatly into data breach reporting. You'll all have read at some point about the obligations around data breach reporting. It's important to recognize, first of all, what the definition of a data breach is, also from Article 4. A data breach is anything. That's the way to think of it. Lost a file, deleted a record by mistake, had a hack, information wasn't available for a couple of days, couldn't do any operations on patients, that's all a data breach. Any compromise of the confidentiality, integrity, or availability of data for the purposes for which it was collected is a data breach. So when the NHS said, as it did after the WannaCry attack, the good news is we didn't suffer a data breach, we just had to cancel a whole bunch of operations because we couldn't access the data. Was a data breach because they couldn't access the data. That's what the data's for. You would be in breach of your obligations as a data controller if that happens, because you're not able to use the data for the purposes for which it was collected. And the data subject, believe it or not, is entitled to bring an action saying that the data breach has caused them significant harm and upset. And I'm prepared to bet quite a lot. For me, I never bet, so a tenner maybe, on the fact that there will be hundreds of people under those circumstances who will bring action saying that the NHS's inability to protect my data has caused me significant personal distress and physical problems because my operation couldn't take place. And they will win. So it's anything. I deleted the file by mistake, all the way through to we were hacked and we had a zillion records stolen, or we've been hacked repeatedly for the last 4 or 5 years. Every single one of our records has been compromised multiple times. So if you're breached, what do you have to do? Well, if you're this is again where being clear about whether in respect of this process you're a controller or a processor is important. The processor has to tell a controller. You don't have an obligation to report it to the supervisory authority. Your obligation is to report it to a controller. So if you don't know who the controller is, like I said, you're in trouble. One of the things that therefore means is that your contract with a controller has to identify clearly how you report breaches. Who to, by when, if the breach happens Saturday night, who do I contact to tell that there has been a breach? All of that needs to be worked out. So in looking at the contract, if you're a controller with your processors, you need to work out how they report breaches to you. If you're a processor, you could have multiple organizations for whom you are processing data. For each of them, you need to work out how you're going to report a breach. Ideally, what you want them to do is incorporate in their contract with you your breach reporting mechanism. Because you don't want to have 10 different ways of reporting breaches if you can avoid it. You really only want to have one. There's going to be an obvious business conflict between processors saying, no, this is how we want to report breaches, we want to do it the same for everybody, and controllers saying, this is how we want breaches reported to us, we want everybody to do it the same as everybody else. And I guess the reality will end up somewhere in the middle. The requirement is to notify the controller without undue delay after becoming aware of the breach. Without undue delay, it turns out, according to the latest guidance, means approximately without undue delay. So, not really much use. Certainly within 72 hours. There's no exemptions. You can't say, nah, this breach isn't very important. You've got to report it. You can't say it's any one file. Who cares? All data breaches have to be reported. Which is a bit silly, because when you delete a file by mistake and you get it back an hour later, it's still a data breach. Can you really imagine reporting every one of those to a controller? And you can really imagine the controller saying, thank you so much, this has been really helpful. So where that's going to iron itself out, we don't know. There's going to be, I think, a whole spectrum of people from organizations at the one end who are saying, yep, everything, sorry, we lost a file. We lost a single piece of paper. Here's the report all filled in. They're going to drown their controllers. To other people saying, no, you can't be serious. That is only 1,000 records. We don't really need to tell you that. And the next couple of years we'll work out actually what the legal expectation is of what that means. But the words at the moment say, no exemptions, every single breach has to be reported. So if you're a processor or a controller, you've got to work out how you're going to deal with that. One of the key areas, frankly, you want to talk to your lawyers about. You want your lawyers to tell you what to do. Because if they're wrong, they've got good professional indemnity insurance.
Sorry, Alan.
Yeah.
So the 72-hour breach notification as is no more then. It's just after becoming aware.
Yeah. So if your argument is, I didn't become aware of it for the last 12 months, and as soon as I became aware of it, I reported it, you're into serious trouble, because the fact it took you a year to be aware of the fact that you've had a data breach indicates that you simply don't have appropriate technical and organizational measures in place to identify that you've had a breach or protect yourself from it. So you're heading for serious fines immediately. So what does a controller do? The controller has to notify the supervisory authority, but the controller has options. Still got the same drive without undue delay and not later than 72 hours. Nobody's giving us clarity as to whether the 72 hours that the processor might have is in sequence with the 72 hours the controller might have, or it's the same 72 hours. Again, we'll find out. The practical assumption is to assume that from point of breach to point of report is about 72 hours. So the logical planning assumption should be, if you've got a processor, you make sure they're reporting to you fast, and you're talking to the controller within 72 hours of the breach. That's probably an assumption on the careful side, but in the next year or two, being careful is probably going to be sensible. It's unnecessary in certain circumstances. You don't actually, as a controller, have to tell the supervisory authority if there is no risk to the rights and freedoms of data subjects. That's really important. There's lots of people saying you've got to report every single breach. You don't. You only have to report breaches if there is a risk to the rights and freedoms of data subjects. Now, in order to determine whether there's a risk or not, you're going to have a process for assessing every incident. And you're going to have a risk assessment methodology that enables you to determine whether there is or there isn't a risk. Because you're not going to be able to get away with saying, yeah, we had a look, and on balance we thought there was no risk, because the question that comes back will be, how did you arrive at the decision? Well, we had a chat. It was cool. We're both happy with it. Really? Show me the methodology? Well, that was it. We had a chat. Is going to get you a bad mark. So you need a methodology that enables you to say, here's the risk assessment methodology, this is what we did, we went through the processes, we arrived at this decision, we didn't report it, all documented, nice and clear and straightforward. This only matters because you'll have another breach or another breach, and sooner or later you'll have an investigation. And the investigation will go back over a number of years and will discover that you've had 3 or 4 breaches which you decided not to report, and you had no proper grounds for not reporting. Fines are going to be based not on the thing that goes wrong, but on the overall accountability the organisation demonstrates to compliance with the GDPR. The ICO in the UK has been explicit that that's the basis on which they're going to proceed. So don't say, this thing happened, I'll hide it away, nobody will ever know. It will be found out. All the fines which are levied now in the UK are based on the history of non-conformance by organisations, not on the immediate breach. Typically the immediate breach simply leads to an investigation which exposes massive negligence across the organisation, going back years. That's what triggers the upper end of fines. It's going to happen exactly with supervisory authorities in GDPR. So when you report, unless there is a risk to rights and freedoms, you don't have to tell the supervisory authority. When you report it, you have to tell them what the breach is, you have to tell them how it happened, what are you doing about it, how did you become aware of it. You can give them the information in stages. You can decide that there's some information you can't release because you're trying to deal with the breach, and releasing the information will compromise the data subjects further. When you're dealing with a serious breach, you'll want to have your lawyers involved almost immediately. You'll want them holding your hand very carefully in terms of how data is shared and with whom. There are a number of steps that lawyers who understand data breach reporting can help you take that will minimize your exposures. So no risk to report if there's no requirement to report if there's no risk. Encryption should become a default step for all organizations, because at the moment encryption is seen by supervised authorities and by GDPR as meaning no risk to rights and freedoms. Pseudonymization of data or encryption of data means there is no risk to the rights and freedoms of data subjects. So if you've got a lost laptop or 500 lost laptops, and they're all encrypted, boot encrypted with FIPS 140-2 level encryption, you don't even have to report the fact you've had a breach. Yes, you've had a breach, you should record it. We had 500 laptops go. It's kind of boring, it's very expensive to replace them, but you don't have to report it to the ICO, because as defined at the moment, there's no risk to the rights and freedoms. Nobody can access the data. Unless, of course, the fact that you've lost 500 laptops means there's a whole bunch of operations that can't take place, and the lack of availability triggers a problem for the data subjects. But it's up to you as a controller to make that decision. Failure to report within 72 hours must be explained. While you're reporting the data breach, you have to have somebody keeping a record of the actions that you've taken to meet your obligations to report. It's a GDPR requirement that you track how you're going about reporting, so that, I guess, when the investigation takes place, they can investigate whether your processes actually existed or whether you made them up as you went along. If there is a high risk to the rights and freedoms of data subjects, then you probably have to tell the data subjects themselves. GDPR is explicit that under those circumstances, you tell the data subjects. That means you need to know what high risk is. You go back to the requirement to have a risk assessment methodology, a method of determining what the actual risk is when you're assessing the risk. You can report a data breach to data subjects by any means that's appropriate, as long as it's quick. So you can email them, you can telephone them, you can put, if that's too difficult, you can put advertisements in the newspapers or in social media. And there may be circumstances under which you say, we think this is just a risk, so we don't think we need to tell anybody, and the Information Commissioner can say, I disagree, it's a high risk, get on with it, tell them. And the supervised authority is entitled to make that decision. So you get exemptions if from having to report to data subjects if the technical organizational measures have been taken that minimize the risk. The high risk will not materialize. In other words, you've been able to capture or recapture or regather or recover from the thing fast enough such that there is actually no exposure of the data subjects, or there would be a disproportionate effort in communicating with individual data subjects, in which case, as I said, GDPR says feel free to go to the national press or social media or whatever will ensure that you tell them what's happened to their data. And you can see the logic of the requirement. If you're so bad at protecting people's data that they're exposed, it's only proper that you should tell them so that they can take avoiding action themselves. So if you imagine the recent breach of a credit reference agency where they knew about it for some time, apparently the directors who sold shares didn't know there'd been a breach, which is jolly nice. That would be something that would trigger, again, big fines. The fact that it took them so long, A, to report it to anybody, B, to tell the data subjects what had happened, and C, that it appears that perhaps people were able to trade in the knowledge that the impact on the organization would have been fairly negative. So what happens if you don't behave properly? Well, natural persons have rights. Legal persons don't, natural persons have rights. We all do. That's really exciting. Some of you, I'm sure, will already be experiencing people getting hold of you and saying, you don't have a right to be doing this with my data. That's only going to get more and more interesting. They have a right to judicial remedy where their rights have been infringed as a result of the processing. So a judicial remedy, they can go to their own courts or courts where you're based. They can they can say I've suffered material or non-material damage, and the only way to compensate me for that is by giving me a lot of money. So we've had a breach, I find you've been processing my data for the last 15 years, I didn't know that, you shared it with a couple of people who sent me information about holidays, I didn't realise it was you that was doing that, I'm so upset, I think I'm going to, I've offered my food, all that stuff, I need a lot of money, £25,000 to make it right, and whether they win or lose the case, you're still going to be defending it. So you're going to have a bunch of money tied up in dealing with that. I don't know if you read recently about the young gentleman who led the action that caused the EU-US safe harbour framework to fall over. There's an Austrian citizen, a guy called Schrems, who decided that his personal data was not properly protected under the EU-US safe harbour framework, and he brought a case which went to the European Court of Justice, who said, no, you're absolutely right, it's not. As a result of which the safe harbour framework was knocked over. There was no legal basis for transporting data up to the US for the next 18 months. We now have something called the EU-US Privacy Shield, which I gather Mr. Schrems is not entirely convinced by, but nevertheless it's in place. He's just set up an NGO, non-governmental organisation. He apparently raised £65,000 in the first couple of hours of crowdfunding for the specific purpose of helping data subjects exercise their rights under the upcoming GDPR regulation, specifically to help them set up class action suits to the extent that's allowed, because there's a very specific provision in GDPR which says NGOs can bring actions on behalf of large classes of data subjects whose rights have been transgressed. He said very clearly that he's going after the big, primarily US organizations, which in his opinion have little or no regard for the rights of data subjects, but do you think he's going to be the only guy who thinks this is a neat thing to do? Do you think there's going to be lawyers who think this is a neat thing to do? Because as far as I can see, the PII bonanza is going to be gone in a year or two, because that's got a line drawn under it, it finishes. So what are all those legal firms going to do to keep them going? How many new firms are going to emerge whose speciality is helping data subjects get their rights? How many firms are there helping people get their PII money repaid to them? They didn't exist before that law came into place. So where Mr. Schrems has gone, I'm sure there will be many others following, and they'll be coming along saying, this person has suffered significant non-material damage as a result of your illegal processing of their data. And that's where the fact that you've done it right from the beginning and saying, no, we have a retention schedule, we've got proper appropriate measures in place to protect data, we do all this stuff right, is going to get you off the hook. Where you're scrambling to put it together in the couple of hours before you have to produce a reply is where you'll be in trouble, because it'll be evident that you just put it together now to meet the requirement. The controller involved in the processing is liable for damages caused by the processing. Very explicit in GDPR, it means that if your processor or your sub-processor is where the problem is, you are liable as a controller. You're entitled perfectly to build into your contracts a clawback from the processor. You're entitled perfectly to get from them or from their sub-processors anything that you have to pay, but the reality, the requirement that fines will be effective, proportionate and dissuasive, that they will be levied on the controller, doesn't change. The supervisor's right is going to go after controllers, not processors. So as I said at the beginning of this, getting clear whether you're a processor or a controller in respect of each activity of processing is really critical. The fines, you remember, 10 million euros up to, for the lower tariff, up to 20 million euros or 4% for the higher tariff. And again, just to be clear, these are up tos. This is not what the fine will be. This is an up to based on the extent of negligence inside the organisation. And so the practical planning point for most organisations is to assume A, that you're going to find yourself with a breach, B, that therefore what you've got to do from the outset is be able to demonstrate that you haven't been negligent, particularly around areas where GDPR is talking about take appropriate technical and organisational measures, where as soon as you can go and use outside frameworks and standards to demonstrate what you're doing makes sense. And you should, we believe, but it's simply belief at the moment, be able to use those kinds of arguments to get fines down to either a minimal or a non-existent level. We don't think supervisory authorities are going to want to pursue controllers where they're basically doing everything right, just because there are one or two minor things wrong. There are going to be so many organisations doing so many things seriously wrong that if you can demonstrate that mostly you've got it right, we suspect that you're going to be all right. But in case you're not, make sure that your lawyers have given you advice that if it turns out to be wrong, you can take action against them. So the nature, gravity and duration of the infringement, the intentional or negligent character, anything you've done since the incident to reduce damage to the data subjects, and the degree of responsibility of the controller or processor, all of those have to by law be taken into account. So GDPR isn't just saying you go stick a fine. The fine, yes, has to be effective, dissuasive and proportionate, but it has to be on the basis of taking account of all of those aspects. We do not expect that there will be fines under GDPR on the 26th of May. It's impossible, because somebody will actually have to have reported a breach of GDPR prior to there being a fine. It'll have to have been investigated. And the breach will have to be of GDPR, not of the Data Protection Act. So we don't think there'll be fines for a number of months. There's going to be a grey area where people will report breaches of the GDPR, which actually breaches the Data Protection Act. You can't be fined for a Data Protection Act breach on the basis of the GDPR tariff. It's just not how the law works. But if you're processing data unlawfully on the 25th of May, you're in breach on the 25th of May. So somebody could report you on the 25th of May and say this organisation is processing my data unlawfully. And I'm absolutely sure there will be a number of those kind of reports going in. The one thing we're all quite hopeful of is that the ICO is understaffed. So the controller is liable for damage caused by the processing. The processor is only liable where they've processed outside the provisions of a contract with a controller. So as I said, getting clear whether you're a controller or processor is really critical. If you're a processor, making sure that there is a contract and that you're operating inside of it is critical. It means then that any problems there are will be levied directly on the controller, not on you. So, controllers, joint controllers, how does that all work? It's worthwhile just having some clarity about the different options, particularly around controllers. Article 26 talks about joint controllers, recognises there are circumstances under which two or more organisations might get together to collect information. They each intend to do different things with that data. And that happens quite often. You can have organisations doing joint marketing, for instance. They're collecting the data, they're going to do different things with the data. All GDPR says is that, therefore, they're joint controllers. The working party guidance and the what's called Working Party 29 is a European Commission working party. It's the working party that was responsible for creating GDPR. It's the working party whose members are expected to become the European Data Protection Board, responsible for ensuring consistent application of GDPR across Europe. They're currently issuing guidance on what GDPR means, which sadly, as we read it, mostly says it means whatever we wrote. The detailed guidance doesn't give you a whole lot more helpful insight. But what they've said around joint controllers is that where joint controllers, where two organisations are collecting data jointly, they should appoint one establishment which has the power to implement decisions about the processing with respect to what the joint controllers want to do. So one entity to which you can go and ask questions about what are you doing with my data, where is it, who is it accessed, and so on. It's a recommendation, it's not a legal requirement, but working party guidance will tend to be treated by the courts as of significant guidance level. It's not guidance like from me, for instance. So my guidance is jolly exciting, but it's got no legal weight at all. Working party guidance has. So joint controllers, it's perfectly reasonable for two organisations to get together and collect data. You just have to make it easy for data subjects to know what's happening to their data and where to go. So Article 26 says between them, the joint controllers have to determine in a transparent manner what their individual responsibilities are, how they're going to exercise them, how they're going to make it easy for data subjects to access their data. How do the data subjects access their data? Who is going to deal with providing access to the data? Who's going to provide information about where the personal data is stored, what the retention plans are, and all of that kind of stuff. So it's up to the joint controllers to work out how to do it. If they fail to, as a data subject, of course, your rights have been transgressed. It's very upsetting. You know, you're off your food, all that kind of stuff, and you go and bring an action. So Joint controllers, by means of an arrangement, has to be made available to the data subjects. They have to be able to understand how the joint controllers put it together, what they agreed to do. They're jointly and severally liable. Jointly and severally means if one of you goes out of existence, we can chase the other one for the entirety of what we're chasing for. Joint and several is a specific legal term. And any controller is exempt from liability if it can prove no responsibility for a data breach. So you've kind of got a prisoner's dilemma where joint controllers are concerned. Do you cooperate? Do you act against one another? Or what? It's going to be another massively fun area over the next few years. And then finally, controllers have to think about what they're doing if they're not in the European Union. So there are many organisations who provide services into the European Union. About 250,000 of those will be UK companies after Brexit, which will be providing services into the European Union, which will have to comply with the requirements in Article 27, where the control process is not established in the Union. So one of the many exciting side benefits of Brexit is that we'll all be outside the European Union from some date from March 2019 onwards. And that means that you have to designate in writing a representative in the Union who is established where the data processing or profiling is taking place, where most of it is taking place. The representative has to be an organisation or entity that can be approached by data subjects and by supervisory authorities, and is in a position to represent you. The fact that you've got a representative, of course, doesn't absolve you of your obligation as a controller or processor to comply with GDPR. So that means that most companies in the United States or India or anywhere in the world providing services into the European Union, the definition of providing services is, am I trying to sell something into the European Union? It doesn't have to be for money, it can be provided for free. And it's relatively easy to work out because you'll have a delivery address in the European Union, or you'll process payments in euros or sterling. Any one of those will be indicators of the fact that you're providing services into the European Union. Even if you don't sell a lot, the fact that you're providing services places on you the obligation to comply. If a European Union citizen happens to go to an organisation in America who's not providing services in the European Union and buy something from them, doesn't force them suddenly to have to comply with GDPR. Nor should it. It would be a kind of crazy thing that you can book into a hotel in the middle of America somewhere that's barely heard of Europe, and suddenly they have to comply with European Union legislation because you're an EU citizen. They're not providing services in the EU, they don't have to comply. So, you're outside the European Union, you have to have a representative. It means you need to find an organisation that understands how to be a representative. There'll be a fee involved, and they'll represent you. Boring if you've got subsidiaries in Europe and your head office in the UK or the US. If the controller is based in the US, you now have to have one of your subsidiaries identified as a representative, or some other third party identified as a representative for you, because you, the controller, the entity is outside the European Union. Processors can appoint sub-processors. Bear in mind that privacy notices, the things which describe to a data subject what you're doing with their data, have to set out if data is being shared with a processor and or sub-processors. That has to be clear to data subjects. If it's going outside the European Union, it has to be clear to the data subject. So as you see, data processors can only process data within a contract with the controller. They can only contract with the sub-processor if the contract with the controller allows it. Remember, the controller determines the means and purposes of processing. If the controller says it's up to you, choose any sub-processor you like, that's fine, the controller can do that. It doesn't change the fact that if something goes wrong, it's the controller's neck on the block. Accountability starts with the controller. So that means from a managing risk in the supply chain perspective, where you're sharing data, and if you think about an e-commerce organization, for instance, which might be drop shipping products, so that you're sending data about the customer to a wholesaler or to a manufacturer, and also maybe they're then sending it on to a shipping company, you've got a series of steps where personal data is being shared at least 2 levels down by organizations who would be processors. You're the controller, you're on the hook for how that data is protected. So you need to make sure that through the supply chain you've dealt with GDPR compliance effectively. Processors cannot engage sub-processors without the controller's authorization. As I said, that authorization, we see no reason why it can't be general. It's likely, we suspect, mostly to be specific because of the challenge around making sure that you're managing risk effectively in your supply chain. So the obligation on sub-processors is exactly the same as the obligation on processors, is to process in line with the contract. You've got to report breaches to the processor, it's got to get reported up the line to the controller, you've got to do all of the same kind of things, apply appropriate technical and organizational measures, delete or return data at the end of the processing. It's exactly the same obligations apply all the way through a sub-processing chain. And of course, there's lots of ways as a company we can help with pocket guides and manuals and toolkits and training courses and consultancy, but questions as well. What would you like to know more about? Yeah.
So, what constitutes personal data? National insurance numbers,
Yep.
Biometrics,
Yep.
a name,
Yep.
email address.
Yep.
So, from a business point of view, I can see us writing to all former employees, we hold your financial data for these reasons, this is when it will be removed, this is why we have it.
Mm-hmm.
Do we need to do that with every single piece of data we have, as in, so, I don't know, marketing information that has to be done for that as well, those purposes, any personal data we hold, we have to do
Yep.
that for.
So if we're deleting, say for the employees' records, past employees' records, if we're deleting that data ahead of 25th of
Yeah,
May,
that's the smart thing to do.
we don't need to write to them to say we're deleting the data.
Well, you only have to comply with the Data Protection Act. The Data Protection Act doesn't have any requirement in it that we can see that says you have to notify data subjects
No,
you're
okay.
deleting their data, or that you have permission to do it, because the definition of data and data processing is not as wide under the Data Protection Act.
No.
What the Data Protection Act does say is you shouldn't hold data longer than the purpose for which you collected it. And if you're holding data, as you probably are, you should have got rid of it just to comply with GDPR. So I would paint deleting data right now as catching up with our Data Protection Act compliance obligations.
Okay.
After May, I suspect that deleting data is something you'd have to tell data subjects about. So I suspect if you were following the letter of the law, you'd be saying, I'm processing your data, I shouldn't be, I recognize that, so I'm deleting it, I'm just letting you know that we have to delete it to comply with the law. That's the lawful basis on which we're doing it.
Could we put something in employee contracts which say data will be held according to law and deleted once that
You need to do
time's up?
more than that, because I'm prepared to bet that most employment contracts will say we're processing your data on the basis of consent.
Right.
Yes? I'm prepared to bet. Anybody here remember what their employment contract says? Apart from the bits about how much you get paid?
I don't think it says anything about it.
It will. It'll have a thing in there, it'll be hidden somewhere, which will maybe up front it'll say, and you consent to us processing your personal data for the purposes of this employment, or words to that effect. That's invalid under GDPR. It's invalid for two reasons. The first is that consent under GDPR is defined as something that has to be freely given. Freely given means between two equal parties, and the supervisory authorities are crystal clear that an employer and employee are not equal parties. Therefore, it's consent given under duress, therefore it's invalid. So every employment contract which depends on consent is invalid on the 25th of May next year, by definition. So that means you have to contact every single current employee and say, we're changing the basis on which we're processing your data. That's the first thing. The second thing is that you need to have multiple different bases for processing, because you're processing multiple different types of data. You're processing it, it's one of the big challenges around GDPR, is you're processing, for instance, identifying data, name and address. What do you need to process that data for?
What, for current
Sending back.
employees?
Yeah.
What, for their payslips, for their...
Do you need their name and home address for their payslips?
I think you do for HMRC, wouldn't you?
Do you send their payslips out by snail mail?
We don't, but they have them on their payslips for...
Do they need to have them on their payslip?
They have to have their name.
Okay, you have to. But I'm not telling you what the answer is. But the questioning you have to go through is exactly this.
Yeah.
The assumption is you collect all this data, and there must be a reason, therefore you collect it. the requirement to have an explicit purpose means, what do I need this for? So you think about a website where you go on and say, I want to download this piece of information. It says, give me your email address, your name, your home address, and your date of birth. What is your date of birth necessary for to download a paper? Why do they need your street address to download a paper? They don't. That's asking for data which is not relevant to the specific purpose which is being collected. So with employees, you've got to go through that. So you collect that data. You're going to want bank details, aren't you? And the purpose for which you want bank details is to pay them. Okay, so how long are you going to keep their bank details for?
Well, so you only need it for the time of employment.
Correct. So there's no lawful basis to keep it at the point they leave you. You're going to keep payslip records. How long will you keep those for?
I don't know, I would have thought it's 7 years for the...
Okay, so you're keeping them for a period of time because there's an HMRC requirement to keep tax records. So you've got to think about all of the data you're collecting, and you've got to say to a data subject, an employee, we're collecting this data for this purpose, we'll keep it for that long. We're collecting your bank information so we can pay you. The lawful basis for collecting that is in order for us to fulfill a contract, because we've got a contract to pay you, so we have to have that data. We're going to collect payment information for you in order to pay you. We're going to keep it for 6 years in order to meet our statutory obligation to HMRC. So you have to granularize the information you're collecting and set out for each of those types of data the lawful period, the lawful basis of collection, and the retention period. What that I think means for most employment contracts is you're going to say, and we're going to process your data on the ground set out in a particular policy or in a handbook, because those may change. You don't want to have to go back and change employment contracts whenever there is a change or an update in any of that. So much as you do with a number of other things, maternity, paternity, and all of those kind of things, you refer to an employee handbook. I think that's what most sensible organizations will do with the lawful basis for processing data. But it's a big piece of work. You've got a lot of employees. Just think about the fun of going to hundreds or thousands of employees and say, we need to change your contract to employment. Think about all of the opportunities people can have to say, well, in that case, I want to talk to you about my position, my salary, all of those kind of things.
So on the back of that, if you're not obtaining consent, it's on a lawful basis, what information can they ask for?
Sorry, come again?
If it's, so on that basis, it's lawful and you're doing something on a lawful basis, you're not specifically asking for consent, what as a data subject can they ask for?
Right, so lawful basis is, in simple terms, the legal ground for processing data. One lawful basis is consent. Another lawful basis is in order to fulfill the contract we have with you, the data subject. A third is in your vital interests. A fourth is in order to deal with a particular legal case. A fifth is in order for us to meet our statutory obligations. So Article 6 of GDPR sets out very specifically what the legal grounds for processing data is. And for every element of data you're processing, you need to identify one of those 6 grounds. The practical advice is try not to make it consent. Because consent automatically in law triggers the right to withdraw consent. And if you, apart from the validity issue of consent is only valid if it's freely given between, therefore, parties of equal power. The very fact that somebody can withdraw consent, if you need their data to comply with the contract, gives you problems. So if you think about an e-commerce sale, I'm going to sell you a fridge. I need to have your delivery details in order to deliver the fridge. I need to know name, address, street address, all of that kind of stuff in order to deliver a fridge. I need to know when somebody's there because somebody's going to have to sign for it. You don't want to ask consent for that information because if they withdraw consent, you still have a contract to deliver a fridge, but you can't because you don't know where you're going to deliver it to. They've withdrawn consent to processing their information. And they're going to be pains in the arse who are going to do exactly that. And you're going to be stuck with, I have a contract to deliver this thing. Where do you want me to deliver it to? Well, that's your problem, mate. I want compensation. I can't imagine how they're going to make it stand, but there will be people who waste time. So you do not want to rely on consent. You're going to say, and you have to give us this information. The lawful basis on which you're giving it to us is so that we can meet our obligations under a contract. If you wish to object to the processing, this is where you go to on our website and you object, the consequences are that you avoid the contract. But legally, you can't say if you withdraw consent to the processing of this data, you'll void the contract, because the consent in law is focused only on the fact that the consent was given to processing that information. It doesn't have a bearing on the contract. So it's really important, and one of the things that, unless it's crystal clear what your legal basis for processing is, it's one of half a dozen areas where you really should be sitting down talking to lawyers saying, I want written instruction from you on what we should be doing here. Because the consequences of getting it wrong are quite tough. And you want to, if your lawyers say, well, belts and braces, you say, don't belts and braces me, I've got to run a business. So I need something that will actually work. And that means you've got to sometimes do scenarios, say, okay, are you saying if X, then Y? That doesn't work for me. Come up with a better thing, or I'll find some other lawyers who work. Because GDPR does not make it impossible to run businesses. What GDPR is doing is saying, do this properly and transparently. And there is a solution to just about everything that most organizations want to do, other than the stuff that you want to do where you don't want to tell the data subjects. There isn't a solution to that. Yeah.
We're we've got lots of subsidiaries throughout the world, and we've done sort of like a high-level DPI in the UK and stuff like that. So our view is now, because the responsibilities, the head offices in EU, we need to obviously have these subsidiary companies compliant as well. One of the things that, so we're in the process of doing that in more detailed DPI, we have to obviously do with those, because I think lawyers' definition of data on IT definition is quite different. So things that we're finding is obviously storing payrolls on USBs and all these kind of things that we'll be looking at. But one of the technical question I got is one of the things that we do is send payroll data to the UK, they review it and send it back. Do we need consent to do that? And unfortunately, one of the countries we do deal with is Argentina. And from my understanding, wasn't that on the blacklists of the EU regarding data processing?
The good news is the EU doesn't have any official blacklists.
Oh, well.
It's only got official whitelists, which Argentina isn't on. Venezuela is.
Okay.
If your EU business is sending data to the UK, that's perfectly reasonable. At the moment you're inside the European Union, you can move data around without a problem. Beyond March next year, your EU business will be exporting data to be processed in the UK. So all you need is a lawful basis, a legal way of doing that. And a legal way of doing that is either there will be a finding of adequacy, which I think is unlikely because time just won't make it possible. Therefore, there's unlikely to be a privacy shield in place by that time. Therefore, you're going to have to rely either on standard contract clauses or more likely on what are called binding corporate rules. Either one of those, there are different formats of coming at the challenge of how does an organization legally share data with an organization that isn't operating in a jurisdiction which is identified as having adequate data protection. And essentially, it's a very tough set of contractual clauses which says that the entity in the European Union will ensure that the processor with whom it's sharing data complies with all of the requirements to protect data. And that's what you would do. You would put in place probably binding corporate rules across the whole of the group, and you would make sure you enforce them. Your processor in the UK would have a representative in the European Union, which will almost certainly be the head office, because they're processors, they have to have a representative, and that's how I'd address it.
We plan to have data controllers at each business unit.
Okay.
And stuff like that, and for them to do obviously.
Okay, so data controllers is not a right word for this. It's
we call them data champions.
Data champions is good.
Okay.
Yeah, data controller is a specifically defined term in GDPR. So
yeah, I understand that. So also like corporate company secretary will be the controller. We don't really deal with that. Yeah, champion. It mixed up with all these names.
Yeah.
But our view is that obviously we just clearly need to identify what's there, and then obviously do the risk assessments about that and take the appropriate actions and have the breach procedures in place. That's what we're trying to do. But,
I mean, that's the practical approach, is to work out what data you're holding, get it onto a proper lawful basis, and then protect it and have a data breach reporting mechanism. Then you're in with a chance. It's going to get another 12 or 18 months worth of work before you're genuinely compliant with the GDPR. It's kind of a 18-month to 2.5 year program to embed GDPR compliance in the organization. But as a starting point, you just got to build a fortress around the data. You need to know what it is, make sure it's legal and protected.
I think in the UK we don't really deal with consumers. It's mostly just internal employees with the personal data thing. So we were thought for the last couple of years for easy compliance, and we've got set procedures in place, but now we realise that all the subsidiary companies are in, and they do have policy, customer-facing products, realise it's a bigger task.
Do bear in mind that business email addresses are also personal data. Okay, there was a soft opt-out under PECR which you can treat as being non-existent. Personal data, Alan Calder at itgovernance.com is as much personal data as Alan Calder at gmail.com.
Is it their personal email address, or is it the company email address?
So the company email address, info@itgovernance, is the email address of a legal entity. So it's not protected because GDPR applies only to natural persons. Alan Calder is a natural person, so Alan Calder at itgovernance.com is personal data. That identifies me.
Yeah.
Service Centre at itgovernance.com is a corporate email address. It's not protected because legal entity is not protected.
Thanks.
I just want to understand the definitions of control of a process. Whether is that sort of pitched at the organisational level. So you have a company who is the controller, and a third party like Hamilton Spencer's, for example, is a processor, or if you have an HR director, that's a controller for their department, and they have a clerk in the HR department who is a processor.
Right, so there's a crossover between definitions that were common under the Data Protection Act, which might have been something like the second set of definitions you're talking about. You want to, for clarity's sake, drop all of that as you go into the world of GDPR, because controller and processor is a legally defined term in GDPR, and the definition applies to the role of the organisation in respect of a particular set of processing. So an individual organisation can be a controller in respect of 2 or 3 processes, and a processor in respect of 2 or 3 other processes. So if you think of a payroll outsourcing company, they're a controller in respect of their staff. They determine what data to gather about their staff. They're a controller in terms of their relationships with their customers, because again, they work out what information they need to have about their customers, talk to their customers, bill their customers, and all that kind of stuff. But they're a processor in relation to their customers' payroll, and they're processing that data on instruction from their customers. So that's important. You need to recognize that the controller-processor definition is at a process level, not at an entity level. It's what is the entity's status in relation to this process. And you can have multiple aspects of this. And that therefore means you need to think about other terms for the people who have responsibilities. And given that GDPR is now supposed to become embedded in the organization, you would simply talk about things like the accountable person. You'd build into the HR director's role. You are accountable for all of the processing of data inside your department. Think about what you do with health and safety. You might have somebody who provides health and safety advice to the organization, but it's part of everybody's job. You've got to think exactly the same with GDPR. It becomes part of everybody's job, rather than, you've got a specific role in this department. Everybody has a role.
I was concerned about liability, the idea that because you mentioned they'd be liable to the controller.
Correct. That's why the definition is so important. The controller or processor is a legal entity.
Right.
And remember, a legal entity can be a partnership, but it's an entity.
That's good. Thank you.
Other questions? Everything nice and clear? What are you not clear about?
Everything about it really. I think it's one of these things where you dive into it and you realise how more complicated it is. I mean, we sort of like did everything at high level, and it looked pretty simple. We've got the policy written and everything like that, and then now we sort of like diving in a little bit more and thinking, yeah, well, hang on. So you start realising where personal data is. That's why the survey that you do is so important. As you start realising where it is, that itself complicates matters.
Yeah, and that data inventory is such an important step. That's when you realise that your HR data is spread over 7 different spreadsheets, and you go, how do I protect this? Yeah. Okay, well, good luck. Have a happy Christmas. Just think as you wake up on Christmas Day, you've got 5 months left.